You're watching Sovereign Judgment, and I'm glad you're here. Today's story is about an HOA that thought a $12,000 fine would make a quiet property owner surrender a guest house. They had the notices, the committee badges, and the confidence of people who had never had to prove ownership in daylight. I had a deed, a survey, and enough patience to let them put every mistake in writing. Before we begin, tell me where you're watching from. I always like seeing how far these stories travel. Here's what happened. The first thing I heard was the pool gate closing. It made a flat, metallic sound in the afternoon heat, the kind that carries across concrete and water. Behind it, 53 residents stood on the deck of the Silverleaf Commons community pool, holding paper plates, wet towels, and phones they had forgotten to lower. A county survey crew had just finished setting the last orange-topped iron pin into the ground, 6 feet outside the pump house wall. On the other side of the fence, Marlene Voss, president of the Silverleaf Commons Homeowners Association, stood in a white linen blazer with a gold HOA badge pinned to the lapel. She was holding a folder with my name on it. She had mailed me a $12,000 fine for my guest house. Now she was being told, in front of her board, her attorney, 2 sheriff's deputies, and half the neighborhood, that the pool she had been using as the centerpiece of her authority was not on HOA land, it was on mine. The sign my contractor installed that morning was simple black lettering on white aluminum. Private property, parcel 14B, annexed by owner. Used by written permission only. Marlene read it 3 times. Then she looked at Deputy Rains and said, "You can't let him steal our pool." The deputy looked down at the recorded plat in his hand and said, "Ma'am, according to the county, he already owns the ground under it." That was the moment her face changed. Not anger, not fear, something quieter, recognition. To understand how a guest house fine ended with an entire HOA losing control of its community pool, you have to go back to the first certified envelope. My name is Daniel Mercer. For 27 years, I worked as a licensed civil engineer, specializing in subdivision infrastructure, boundary reconciliation, stormwater easements, and post-construction compliance. That sounds dry, because it is dry. Most of my career was spent reading plats under fluorescent lights, comparing old legal descriptions to newer parcel maps, and finding the one line nobody had bothered to check. My father used to say that dirt remembers. He bought our land in 1986, back when Silverleaf Commons was still orchard ground, and the nearest paved road ended at a grain co-op 2 miles south. The property was not large by rural standards, but it was ours. 9.84 acres, on the low shoulder of Bellwether Ridge, with a limestone creek on the east side, and a stand of black walnut trees. My mother refused to let anyone cut. Dad built the main house himself. Not quickly, not cheaply. Board by board, pay period by pay period. I still remember the smell of wet sawdust in the evenings, and the sound of him brushing mortar dust off his jeans before dinner. The guest house came later, after my mother's knees began to fail, and my sister needed a place to stay during her divorce. It was a modest structure, 612 square feet, cedar siding, 1 bedroom, 1 bath, 1 small porch facing the trees. It was permitted in 1998. Final inspection signed on October 14, 1998. Certificate of occupancy issued October 19, 1998. I know those dates because my father kept everything. He had 3 filing cabinets in the mudroom, each labeled in pencil. Taxes, vehicles, land. When he died, I opened the land drawer first. Inside were deeds, utility agreements, septic permits, inspection cards, handwritten notes from county surveyors, and a faded yellow envelope containing the original boundary survey from Price and Leland, dated May 3, 1986. That envelope became important. Silverleaf Commons was built years after our house. The developer, Ashwell Communities, bought 146 acres around us in 2004 and turned the orchard into cul-de-sacs, retention ponds, vinyl fencing, and street names that sounded like birds: Heron Way, Finch Hollow, Larkspur Bend. My father refused to sell. Ashwell offered him $420,000 in 2005, then $515,000, then $575,000 plus a lot inside the subdivision. He said no every time. I bought ground, he told me, not approval. So the developer built around him. They curved the entrance road to avoid our driveway. They placed the clubhouse on the south side of the subdivision. They built the pool near the old property line, where our walnut trees shaded part of their parking lot in the late afternoon. For years, we had no conflict. Silverleaf residents waved when they walked their dogs. Kids chased lost tennis balls into our ditch. My mother used to give tomatoes to a woman named Elaine Porter, who lived 2 doors down from the pool. Then the original residents aged out, moved away, or rented their houses. The HOA changed. The quiet assumptions hardened into rules. And in March of 2024, Marlene Voss became president. I first met her on April 6th at 9:12 in the morning. I was replacing a loose board on the guest house porch when a silver SUV pulled halfway onto my gravel driveway. The passenger side tires stopped in the grass. The vehicle stayed running. Marlene stepped out with a clipboard. She was in her late 50s, narrow and upright, with silver hair cut into a sharp angled bob that didn't move in the wind. She wore white driving gloves even though it was already warm. The gold badge on her blazer said President, Silverleaf Commons HOA. Behind her stood a man I later learned was the vice president, Conrad Pike. He had a red face, mirrored sunglasses, and the posture of someone who liked arriving as backup. Marlene did not introduce herself. She looked at the guest house and said, "This structure is not approved." I set the board down on the sawhorses. "Approved by whom?" I asked. "By the Architectural Review Committee." I wiped my hands on a rag and walked down from the porch. I did not move quickly. My father taught me never to hurry when someone else is trying to create urgency. "This property is not in Silverleaf Commons," I said. Marlene smiled like she had practiced for resistance. "That's a common misunderstanding. Your property is surrounded by the association and receives community benefit. Under our governing documents, exterior structures visible from common areas must comply with community standards." "Which document says that?" She tapped the clipboard. "The covenants. Can you give me the book and page?" Her smile thinned. "You'll receive formal notice." Conrad Pike took one step forward and pointed at the guest house. "That looks like a rental unit. Rentals require HOA approval." "It is not a rental unit," I said. "Then why does it have a kitchen? My mother lived there after her surgery." Marlene wrote something on the clipboard. "Occupancy is not the issue. Unauthorized accessory dwellings are subject to fines of up to $500 per day." I looked at the blacktop road behind her, then at the pool beyond the cedar fence, where the first swimmers of the season were gathering under blue umbrellas. "Do you have a parcel number showing my land is part of your association?" She stopped writing. Conrad answered for her. "You're inside the community perimeter." That wasn't my question. For the first time, Marlene looked directly at me. "Mr. Mercer, cooperation will be much easier than confrontation." I nodded once. "I agree." Then I asked them to leave my driveway. They did, but not before Conrad photographed the guest house from 3 angles. I photographed him photographing it. At 9:23 a.m., I wrote the time, date, temperature, and license plate number in the black field notebook I keep on the kitchen counter. The certified envelope arrived 5 days later. The letterhead looked official at first glance. Silverleaf Commons Homeowners Association, Office of Covenant Enforcement. There was a blue seal with a pine tree in the center, though Silverleaf had no pines anywhere on the property. The notice stated that I was in violation of Article 9, Section 14 of the Silverleaf Commons Declaration of Covenants, Conditions, and Restrictions. Alleged violation: unauthorized detached guest residence. Initial fine: $2,000. Continuing penalty: $500 per day. Compliance deadline: April 20th, 2024. As of the date of the letter, they claimed I owed $12,000. They demanded that I either remove the guest house, apply for retroactive HOA approval, or submit a $1,500 architectural review fee. At the bottom, in bold type, it said failure to pay may result in legal action, lien placement, suspension of community privileges, and referral to collections. I read the letter twice. Then I made coffee. My father's old filing cabinets were still in the mudroom. The drawer marked land, opened with the same little scrape it had made when I was a child. I pulled the 1986 survey, the 1998 guest house permits, the septic inspection, the certificate of occupancy, and the 2004 correspondence from Ashwell Communities. Then I went to work. The first rule in a property dispute is simple: never argue from memory when the record exists. I started with the Merrill County Assessor's online parcel viewer. My property was Parcel 14. Legal description: Mercer Ridge Homestead Tract, 9.84 acres, recorded in Deed Book 771, page 212. Silverleaf Commons wrapped around it on 3 sides, but the map showed no overlap. Then I opened the Merrill County Register of Deeds database and searched Ashwell communities from January 1, 2003 through December 31, 2006. There were 42 recorded instruments: subdivision plat, drainage easements, road dedication, utility maintenance agreement, declaration of covenants, supplemental declaration, clubhouse parcel transfer, pool construction mortgage release. I downloaded all of them. The declaration of covenants was recorded on August 18, 2005, in Book 1142, page 88. I went directly to Article 9, Section 14. It did not concern guest houses. It concerned mailbox color. Specifically, it required that all mailbox posts within Silverleaf Commons be painted Charleston black or an approved equivalent. There was no mention of detached structures, accessory dwellings, surrounding properties, perimeter benefits, or non-member parcels. I printed the page. Then I searched the document for my parcel number. Nothing. I searched for my father's name. Nothing. I searched for Mercer, Homestead, Adjacent, Surrounded, and Benefit. Nothing. That should have been the end of it. But while reviewing the original subdivision plat, I noticed something that made me sit back in my chair. The pool parcel was wrong. Not obviously wrong. Not in the way most people would see on a first pass. The recorded plat labeled the clubhouse tract as Common Area A, containing 1.72 acres. The pool, according to the HOA's website and every sales brochure I found, was part of Common Area A. But the Mets and Bounds description for Common Area A stopped at an old stone marker near the south end of the pool deck. The pool itself, the pump house, the equipment enclosure, and a 12-foot strip of the concrete apron extended north beyond the described boundary. I opened the 1986 Price and Leland survey and laid it beside the 2005 subdivision plat. The line matched my father's survey. Then I pulled the pool construction permit from the Merrill County Planning Archive. Permit PC 2006-1187, issued to Ashwell Communities on May 12, 2006. Site plan attached. The site plan showed the pool fully inside Common Area A. But the site plan was not the recorded plat. That difference mattered. A construction drawing can be wrong. A recorded deed controls ownership. I kept digging. The pool had been built partly on a sliver of land labeled Parcel 14B on the assessor's map. 0.38 acres. Tax-exempt status unresolved. It sat between my main parcel and Silverleaf's Common Area A like a forgotten seam. I had seen that number before. In my father's file cabinet, inside the yellow envelope, there was a handwritten note from 1987. 14B, retained for drainage access if county ever asks. Attached was a quitclaim deed from the original orchard owner, conveying Parcel 14B to my father. Recorded in Deed Book 779, page 301. Ashwell had never bought it. The HOA had never owned it. The county had never corrected the visual parcel layer because Parcel 14B had no separate tax bill. It had been assessed as part of my father's homestead for almost 40 years. The pool was not just encroaching on my land. A majority of its operational infrastructure sat on my land. The pump house, the filtration tanks, the chlorine storage room, the electrical service disconnect, the backwash discharge line. I remember the quiet in the kitchen when I realized it. The refrigerator hummed. Outside, a crow hit the bird bath and flew off. My coffee had gone cold. I did not call Marlene. I did not post online. I did not tell the neighbors. I scanned every document at 600 dpi, saved 3 copies, and placed the originals back in the cabinet. Then I drove to the courthouse. The Merrill County Records Office still had brass door handles and a marble floor worn dull in the center from a century of footsteps. At window 3, a clerk named Ruth Bellamy helped me pull the physical deed books. Ruth had worked there 31 years. She wore a green cardigan and used a magnifying glass without apology. When I asked for Deed Book 779, page 301, she looked over her glasses. Parcel 14B? I nodded. That one causes questions every few years. What kind of questions? Usually from Silverleaf people. She carried the book to the counter herself. The deed was there. My father's name was there. The legal description was there. The recording stamp was there. I requested 3 certified copies. Then I requested certified copies of the 2005 Silverleaf Plat, the Declaration of Covenants, the Common Area A transfer deed, and the 2006 pool permit. Ruth stamped each one with steady hands and slid them through the window. "Whatever this is," she said quietly, "make copies before you give anybody originals." "I will," she smiled. "I figured you would." By the time I got home, there was a second envelope taped to the guest house door. Not mailed, taped. That mattered. The notice said the fine had increased to $14,500 and that access to Silverleaf amenities was suspended pending compliance. I had never used Silverleaf amenities. I photographed the envelope in place, the tape, the door, the shadow line showing time of day, and the tire tracks in the gravel. Then I removed it with gloves and placed it in a clear sleeve. The escalation began the next morning. Marlene posted in the Silverleaf Commons Residence Forum at 7:41 a.m. The post said the board had discovered an illegal rental compound operating inside the community perimeter and was taking action to protect property values. She did not name me, but she included a photograph of my guest house taken from my driveway. Conrad Pike commented beneath it, "Some people want our amenities without following our rules." By noon, 27 residents had commented. Most had never met me. A few accused me of running short-term rentals. One said the guest house was probably unsafe. Another asked whether children were in danger. Elaine Porter sent me screenshots. Elaine was 74 by then, and still lived 2 doors down from the pool. Her husband had died the previous winter. My mother's tomato friend had become a careful woman who kept blinds half closed because the HOA had fined her $800 for leaving a wheelchair ramp in place after Harold's funeral. Her message said, "I thought you should see what they're saying." I thanked her and asked her not to comment. At 2:16 p.m., I received an email from a company called Covenant Recovery Services demanding payment of $14,500 plus a $375 administrative fee. The signature block identified the sender as Bryce Talbot, Senior Compliance Counsel. I searched the State Bar Directory. No Bryce Talbot. I searched the Secretary of State Business Registry. Covenant Recovery Services, LLC, had been formed 9 days earlier. Registered agent, Marlene Voss. Mailing address, her home on Heron Way. I printed that too. 3 days later, a tow warning appeared on my truck while it was parked in my own driveway. It said vehicles associated with non-compliant properties could be removed at owner expense under Silverleaf Parking Regulations 6.2. I pulled the parking regulations from the HOA portal. Section 6.2 applied to vehicles parked overnight on association-owned streets. My driveway was not an association-owned street. I called Merrow County Sheriff's non-emergency line and filed an informational report. Deputy Alan Rains came out at 4:35 p.m. He was a square-built man with a sunburned neck and a habit of repeating facts back before writing them down. "No threat made?" he asked. "Not directly. No vehicle moved?" "No. Just a notice placed on private property?" "Yes." He looked toward the pool. "You and Silverleaf have an ongoing dispute? They believe my guest house is subject to their covenants. Is it?" "No." He wrote that down. I did not mention Parcel 14B yet. There was no reason to. A fact revealed too early becomes an argument. A fact revealed at the right time becomes a record. On April 19th, 1 day before their compliance deadline, Marlene came back. This time she brought Conrad Pike, a board secretary named Felicia Grant, and a man in a Navy suit who introduced himself as legal representative, Nathaniel Crow. Crow handed me a letter. It demanded access to inspect the guest house within 48 hours. It cited association authority over integrated perimeter properties and warned that refusal would be treated as evidence of concealment. I read the first paragraph while they stood in my driveway. Then I looked at Crow. "Are you an attorney?" He adjusted his cuffs. "I represent the association in compliance matters." That wasn't my question. Marlene stepped in. "Mr. Crow has extensive legal experience." I looked back at him. "Are you licensed to practice law in this state?" He did not answer. Conrad said, "You're making this harder than it needs to be." I folded the letter and placed it back in the envelope. You do not have permission to enter my property. Marlene's voice sharpened. Then we will proceed without your cooperation. That is your choice. Crow pointed toward the guest house. When a structure creates community exposure, the association has inspection rights. Send me the recorded instrument granting those rights. Marlene exhaled through her nose. You keep hiding behind paperwork. I looked at her badge, then at the clipboard in Felicia's hand, then at the pool gate beyond them. Paperwork is what ownership is. Nobody spoke for a few seconds. Then Marlene said the sentence that eventually destroyed her. We have controlled this common area for almost 20 years. Possession matters, Mr. Mercer. If you keep forcing this, you may not like what 20 years of use means for your little technicalities. Felicia's phone was in her hand, recording. So was mine. They left at 10:04 a.m. At 10:22, I emailed the video to myself, saved it to a cloud folder, and backed it up to an external drive. That afternoon, I called an attorney. Her name was Lena Sato. She had practiced property and HOA law for 22 years in the fictional Tri-County region that included Merrow County. Her office was above a bakery in downtown Ashford Falls, and the conference room smelled faintly of coffee and cinnamon. I brought 2 banker's boxes. She did not smile when I explained the fine. She did not smile when I showed her the covenants. But when she saw the Parcel 14B deed and the pool permit, she removed her glasses and leaned back. Daniel, she said, how much of the pool equipment is on your parcel? Based on the old survey, most of the operating infrastructure. Based on the old survey is not enough. I know. She nodded. Good. We need a current ALTA boundary survey, a title opinion, and a written encroachment analysis. No letters until those exist. I asked her the question I had come there to ask. If the survey confirms what the records show, can I legally annex Parcel 14B back into active use and restrict access to the pool infrastructure? She paused before answering. Annex is not quite the legal word I would use casually, but you can file a parcel consolidation acknowledgement, record your ownership, demand removal or license of the encroachment, and restrict unauthorized use of your land after proper notice. If the pool cannot legally operate without equipment on your parcel, that becomes the HOA's problem. Can they claim adverse possession? They can try, but common areas held by an HOA, built from a mistaken permit, maintained under a false ownership assumption, and challenged once discovered, are not simple adverse possession facts. Their own documents may defeat them. Which documents? She tapped Marlene's taped notice. The ones where they claim the guest house is inside their authority, while admitting your parcel is separate enough to fine from outside, and whatever she meant by 20 years of use. I slid my phone across the table and played the driveway video. When Marlene's voice said, "Possession matters," Lena's expression changed. Send me that file. I did. Within 48 hours, Lena had assembled the team. A licensed surveyor named Thomas Kellen from Kellen Boundary Group, a title abstractor named Mira Holt, an electrical inspector named Owen Price, because pool equipment is not a decorative encroachment, and a retired county planner named Judith Ames, who had worked in Merrow County during the Ashwell development years. Everything was formal: engagement letters, scope of work, chain of custody logs, certified copies only, no opinions given over the phone, no casual emails. On April 25th, Thomas Kellen arrived at 7:30 a.m. with 2 survey technicians and equipment cases covered in dust. The morning was cool, and the grass along the old stone line was wet enough to darken their boots. They found the 1986 iron pin near the walnut trees. They found the stone marker at the south corner of Common Area A. They found the discrepancy. By 11:40, orange flags traced a line that cut across the pool complex like a quiet verdict. The pump house was fully on Parcel 14B. The chemical storage room was on Parcel 14B. The electrical disconnect was on Parcel 14B. The north edge of the pool deck crossed 7.8 feet onto Parcel 14B. The water itself remained mostly on Common Area A, but the pool could not operate without equipment standing on my land. Thomas did not give dramatic commentary. He simply looked at his field tablet and said, "Your attorney will get the sealed map by Friday." Marlene saw the survey stakes that afternoon. At 5:03 p.m., she emailed me with the subject line, Cease unauthorized marking of common area. The body accused me of vandalizing HOA property with survey flags. I forwarded it to Lena. Lena replied with 4 words. Do not respond directly. So I didn't. Instead, we prepared. On May 1st, Lena sent a formal notice by certified mail to Silverleaf Commons HOA, Marlene Voss individually as president, all board members, and the registered agent listed with the Secretary of State. The notice was 12 pages long. It stated that Parcel 14B was owned by me as successor to my father's deed. It attached the certified 1987 quitclaim deed, the 1986 survey, the new Kellen Boundary Group survey, and Mira Holt's title opinion. It demanded that the HOA cease unauthorized use of Parcel 14B within 30 days unless it negotiated a written license agreement. It demanded withdrawal of all fines related to the guest house. It demanded retraction of the social media post. It demanded preservation of all HOA communications concerning my property, the guest house, the pool, Parcel 14B, Covenant Recovery Services, and Nathaniel Crow. It also warned that continued operation of pool equipment on Parcel 14B after notice would be treated as knowing trespass. That same day, I filed a parcel status affidavit with the Merrill County Register of Deeds. Not a transfer, not a trick. A recorded clarification that Parcel 14B remained part of the Mercer property chain and had never been conveyed to Ashwell Communities or Silverleaf Commons. The county accepted it at 2:18 p.m. Ruth Bellamy stamped the receipt and gave me a copy. Then I did what my attorney advised. I waited. Waiting is not passive when the other side is impatient. Marlene responded on May 4th with a 6-page letter written on HOA letterhead. She rejected the notice entirely. She said the HOA had exclusive equitable control over the pool parcel. She said my survey was self-serving. She said the HOA would continue operations as normal. Then she made the mistake permanent. She attached minutes from an emergency board meeting held May 3. The minutes showed a unanimous vote to continue enforcement against Mercer until the guest house is removed, and to assert full community ownership of pool facilities by historic use. Historic use. Those words mattered. Lena explained it in her office. They are trying to build an adverse possession theory while simultaneously enforcing covenants against a parcel they do not own. That contradiction will not help them. Can we shut the pool down? Not yet. We issue safety notices first. Then county involvement. Then, if they keep operating, we seek injunctive relief or restrict access to the portion of your property. Which is cleaner? She looked at the survey. Cleaner is letting the county make the safety call. So we did. Owen Price inspected the pool equipment from my side of the boundary, without entering HOA land. His report noted that the electrical disconnect for the filtration system was located on Parcel 14B, and that no recorded access easement existed for HOA maintenance personnel to reach it. He also noted that chemicals were stored in a structure standing on private land without a license agreement with the owner. Judith Ames reviewed the 2006 permit file. Her affidavit stated that the approved site plan appeared inconsistent with the recorded plat, and that the discrepancy should have required a corrected plat or boundary line agreement before final approval. On May 9th, Lena submitted the full package to the Merrill County Department of Building and Safety. On May 13th, the county issued a Notice of Operational Deficiency to Silverleaf Commons HOA. It did not order the pool closed yet. It ordered the HOA to provide proof of ownership, easement, or written license for all pool operating equipment within 10 business days. Marlene had a choice. She could negotiate quietly. She could withdraw the fine, apologize to the residents, and ask for a temporary license while the boundaries were corrected. Instead, she posted again. At 6:28 p.m. on May 13th, she wrote, "Certain individuals are attempting to deprive Silverleaf families of pool access through legal gamesmanship. The board will not be bullied by someone who refuses to follow community rules." This time she named me. By 8 p.m., 3 residents had walked past my driveway slowly enough for my cameras to capture their faces. One shouted, "Give us back our pool," even though nothing had been taken. At 8:14, someone left a wet pool towel on the guest house porch with a note reading, "You don't belong here." I placed the note in a sleeve. I called Deputy Raines again. He came out the next morning. "You have cameras?" he asked. "4. Good." He took the report, looked at the survey stakes, and scratched the side of his jaw. "I'm guessing this is going to get worse before it gets better." "Probably. You planning to block anything?" "Only after notice, and only on my parcel." He looked relieved. "Keep doing it that way." On May 16th, the HOA mailed a new fine notice. Total claimed balance, $24,000. They added $3,500 for community amenity disruption, even though the pool remained open. They added $1,200 for legal coordination. They added $850 for reputation harm. None of those categories existed in the covenants. Lena filed suit on May 20th in Merrill County Chancery Court. Mercer v. Silverleaf Commons Homeowners Association. Claims, declaratory judgment, quiet title, trespass, nuisance, defamation, violation of state HOA governance statutes, and injunctive relief. The complaint asked the court to confirm my ownership of Parcel 14B, void the fines, enjoin unauthorized use of my land, and award damages and attorney's fees. Every exhibit had a number. The 1987 deed was Exhibit 1. The 2005 plat was Exhibit 3. The false fine notice was Exhibit 7. Marlene's social media post was Exhibit 11. The driveway video was Exhibit 14. The emergency board minutes were Exhibit 18. The Kellen survey was Exhibit 21. The pool equipment inspection was Exhibit 24. There is power in numbering facts. It turns noise into sequence. On May 24th, the court granted a temporary status conference. Not a ruling, not yet. Just a hearing date for June 7th. Marlene treated that as victory. She scheduled a community meeting for May 29 and announced that the board would explain the Mercer situation. Elaine Porter forwarded me the notice. Residents were encouraged to attend. Local media was invited. The meeting would be held on the pool deck. Lena advised me not to attend alone, so I did not attend at all. Instead, we made the next lawful move. On May 28th, my contractor, Hal Brenner, filed for a temporary construction fence permit along the Parcel 14B boundary. Purpose: protection of private property during active legal dispute and prevention of unauthorized access to electrical and chemical storage structures. The county approved it the same day, conditioned on clear signage and no obstruction of emergency access to HOA-owned land. On May 29th, at 6:15 in the morning, before the pool deck meeting, Hal's crew arrived. The air smelled like cut grass and diesel. The sun had not cleared the clubhouse roof yet. The pool water was still, pale blue under the dawn sky. I stood with Thomas Kellen, Deputy Rains, and a county code officer named Priya Desai, while Hal's crew placed temporary fence panels precisely along the surveyed line, not around the entire pool, only around my parcel. That distinction mattered. The fence enclosed the pump house, chemical room, electrical disconnect, and the encroaching strip of pool deck. It left the HOA's gate unobstructed. It left the pool water visible. It left the residents with access to the portion of land the HOA actually owned. But without the equipment on my parcel, the pool could not lawfully operate. At 7:02 a.m., Priya Desai placed a county notice on the pool gate. Operational hold pending proof of property access rights. At 7:11, Hal installed my sign. Private property. Parcel 14B, annexed by owner. No entry without written permission. Merrill County Permit TF 24-188. I chose the word annexed because Lena had used it in the recorded affidavit as plain language shorthand for bringing the forgotten parcel back under active management of the Mercer homestead. It was not a municipal annexation. It was not a seizure. It was not a stunt. It was the visible correction of a 40-year boundary error. Marlene arrived at 7:36. Her silver SUV stopped hard enough that gravel jumped beneath the tires. She got out wearing the same white blazer, the same gold badge, and a pair of sunglasses too large for the morning light. Conrad Pike came behind her in a golf cart. Marlene walked straight to the fence. "What is this?" I handed her a copy of the permit through the open space between panels. "This is a temporary protective fence on Parcel 14B. This is our pool. No, your pool is partially dependent on my land." She turned to Priya. "Remove this." Priya remained calm. The county inspected the permit. The fence is placed on the surveyed private parcel. Marlene pointed at me. He is retaliating. Deputy Raines said, "Ma'am, this is a civil property matter unless someone crosses the fence or damages it." Conrad's face had gone red. "You can't close a community pool the day before summer break." I looked at him. "I didn't close it. The county placed an operational hold because your association cannot show a right to access the equipment." Marlene lifted her phone and began recording. "Say that again." I did not. Lena had warned me about giving speeches. Marlene turned the camera toward herself and said, "Silverleaf families, I am standing here with the man who has physically annexed our community pool." That clip went online within 15 minutes. It became the most useful evidence in the case. Because in her own words, on video, she admitted two things: that the annexation had physically occurred along a visible boundary, and that the pool's continued function depended on the area I controlled. The community meeting that evening happened anyway. I did not attend, but Elaine did. She sat in the third row with her cane across her lap and her phone recording from inside her purse. Marlene stood in front of the locked pool gate under string lights that had been installed for Memorial Day weekend. Behind her, my fence panels cut across the pump house like a line drawn through an argument. She told the residents that I had weaponized an obscure deed. She said the HOA had enjoyed the pool peacefully for 18 years. She said the board would pursue all remedies. Then she held up the $24,000 fine notice and said, "Mr. Mercer had every opportunity to comply before he chose this path." A man in the back asked, "Does he own the land?" Marlene answered, "Ownership is not always as simple as a piece of paper." Elaine sent me the recording at 9:42 p.m. I forwarded it to Lena. Lena replied the next morning. She keeps confessing. The June 7 hearing took place in Courtroom 2 of the Merrow County Chancery Court. The room had high windows, old wood benches, and an air conditioner that clicked every few minutes without cooling much. Judge Amelia Corvin presided. I sat beside Lena at the petitioner's table. Marlene sat across the aisle with Conrad, Felicia, and Nathaniel Crow, who was still presenting himself as a legal representative, though he was not counsel of record. The HOA's actual attorney was a man named Grant Madsen. He had been retained 2 days earlier and looked like someone who had received the file too late. Judge Corvin began with the fines. "Ms. Sato, your position." Lena stood. "The fines are void. Mr. Mercer's parcel is not within the Silverleaf Commons HOA. The cited covenant section concerns mailbox color. The association has no recorded authority over his guest house." She handed up the declaration. Judge Corvin read silently for several seconds. Then she looked at Madsen. "Counsel?" Madsen cleared his throat. "Your Honor, the association's position is that the Mercer property is functionally integrated with Silverleaf Commons." The judge looked over her glasses. "Functionally integrated is not a legal description." "No, Your Honor. Do you have a recorded covenant binding Parcel 14? Madsen paused. "Not at this time." That was the first crack. Then Lena moved to Parcel 14B. She entered the certified deed, the 1986 survey, the 2005 plat, and the Kellen survey. Thomas Kellen testified for 11 minutes. He was concise. He explained the boundary, the pins, the stone marker, the equipment placement, and the absence of any recorded easement. Judge Corvin asked him one question. "Is there any surveyed basis to place the pump house within Common Area A?" "No, Your Honor." Then Lena played Marlene's driveway statement. "Possession matters, Mr. Mercer." The courtroom was quiet. Then Lena played Marlene's pool gate video. "I am standing here with the man who has physically annexed our community pool." Marlene whispered something to Grant Madsen. He closed his eyes for half a second. Judge Corvin asked, "Ms. Voss, did you make those statements?" Marlene stood before her attorney could stop her. "Yes, Your Honor, because he did annex our pool." The judge said, "Please answer only the question asked." Marlene sat. Lena then entered the emergency board minutes asserting, "historic use." She explained that the HOA, through its president and minutes, appeared to be asserting control of private land without recorded title, while also imposing fines against the owner of that same land. Grant Madsen tried to argue that the HOA needed emergency access for health and safety reasons. Lena responded with the written temporary license offer she had sent on May 30th. It offered the HOA limited access to the pump house for water stabilization and safe shutdown, under county supervision, without prejudice to ownership claims. The HOA had rejected it. Marlene had written across the offer in blue ink, "We do not need permission to access our own amenities." That marked-up letter was Exhibit 32. Judge Corvin read it. Then she looked at Madsen. "Did your client reject supervised access?" Madsen's voice was lower now. "It appears so." The judge issued a temporary order that afternoon. The HOA was enjoined from enforcing any fines against my property. The HOA was prohibited from entering Parcel 14B without written permission or county-supervised emergency authorization. The pool operational hold remained in place until the association provided proof of legal access to all required equipment or relocated the equipment onto HOA land. The court also ordered the HOA to preserve all records and produce communications within 14 days. Outside the courthouse, Marlene walked past me without looking. Conrad did not. He stopped close enough that I could smell mint gum. "You think you won?" he said. I looked at the courthouse steps. No. Then I walked to my truck. Winning is a word people use too early. The records production began the following week. That is where the dispute stopped being only about me. The HOA's emails showed that Marlene had known about the guest house permit before issuing the first fine. Felicia Grant had found the county permit archive on April 8 and emailed the board. Guest house appears pre-existing and outside HOA, but MV wants pressure applied. MV was Marlene. Another email showed that Conrad Pike had suggested using the fine to bring Mercer to the table because the board had discovered the pool boundary issue during a 2022 insurance review and never disclosed it to residents. That email had the subject line, "Pool Land Problem." Mira Holt found no record that Silverleaf had ever told its members the pool equipment might sit on private property. Then Elaine came forward. She gave Lena her own HOA file, the $800 wheelchair ramp fine, the denial letter, and photos showing the ramp had been removed after her husband died. The same Architectural Review Committee had cited Article 9, Section 14 against her too. Mailbox color. Once Lena requested broader records, other residents contacted her. A retired teacher named Omar Whitcomb had paid $2,300 for a pergola violation under a covenant section that applied only to satellite dishes. A nurse named Janet Pell had paid $1,750 after the HOA threatened to lien her house over a garden shed approved by the developer 20 years earlier. A young couple, Miles and Nora Teague, had been charged $4,600 in rental monitoring fees because Nora's brother stayed with them after surgery. The pattern was not sloppy. It was systematic. Marlene's board had been using official-looking notices, misquoted covenants, and a related collection company to pressure residents into payments most people could not afford to fight. Covenant Recovery Services had collected $68,940 in fees from Silverleaf residents between January 2023 and May 2024. The company was owned by Marlene. That moved the case into a different category. Lena amended the complaint to add claims for unfair collection practices, breach of fiduciary duty, and civil conspiracy. She also referred the matter to the Merrill County District Attorney's Consumer Protection Division. On July 18th, the DA opened an inquiry. On August 2nd, the court certified a limited resident class for restitution related to improper fines and collection charges. By then, the pool had been closed for 65 days. The HOA tried 3 times to reopen it. First, they sent a maintenance worker over the fence at 6:10 a.m. on June 19th. My camera caught him before he reached the pump house. Deputy Raines issued a trespass warning. The worker later testified that Conrad told him the court order didn't count before business hours. Second, they hired a contractor to propose moving the pump system onto Common Area A. The contractor estimated the work at $184,000. And warned that the pool shell might need partial demolition to reroute plumbing. Third, they asked the court to force me to grant an easement. Judge Corvin denied that request. Her order was direct. A party may not manufacture necessity through years of unauthorized encroachment and then compel the burdened owner to cure the party's own title failure. I kept that sentence. On September 12th, the final hearing began. By then, Marlene no longer wore the gold badge. She still wore the white blazer, but it looked less like a uniform and more like something she had chosen, because she did not know what else to be. The courtroom was full. Residents lined the benches. Elaine sat in the front row. Omar Whitcomb held a folder on his knees. The Teagues sat together, with their hands linked. Lena's opening statement lasted 6 minutes. She did not call Marlene corrupt. She did not call the HOA malicious. She simply walked the court through the documents. The deed, the plat, the guest house permit, the false covenant citation, the collection company registration, the pool land emails, the rejected temporary license, the videos, the board minutes. When Marlene testified, Grant Madsen tried to keep her focused on community intent and historic operation. Lena only needed